Laska and Corla, thank you for including this important issue for today's topicals. This is Pregnancy and Infant Loss Remembrance Month, a time to mark the loss in pregnancy or soon after birth. This is an incredibly sensitive matter which represents tragedy and bereavement for thousands of families. Pregnancy loss in the form of miscarriage or stillbirth occurs in up to 1/4 of all pregnancies. This loss can have a devastating impact on parents, other children and family members. It's vital that this particular form of grief and isolation is recognised and supported. Last Friday was the global wave of light when candles, monuments and buildings were lit in all the colours, pink and blue, in memory of lost young lives. I know many families and communities across Ireland marked this day remembering their own loss or showing solidarity with others. Féileacáin, the Stillbirth and Neonatal Death Association of Ireland, is a volunteer-led organisation that supports families affected by perinatal loss. This year they have launched the Remember Our Names campaign, which is calling for an immediate amendment to Section 8 of the Stillbirth Registration Act 1994 to make the Stillbirth Register public. Under the current Act, only parents can view the details of infants on the Stillbirth Register. This register was treated differently to others to protect the privacy of families involved. Reading over the dull discussion of this topic over 25 years ago, the motivation of the Minister and TDs at the time was to recognise the intense personal nature of this matter. However, our understanding of pregnancy and infant loss has developed since then, and the families directly affected are calling for a change. Féileacáin's Remember Our Names campaign highlights that a mandatory sealing of this register hides away the details of their lost infants. Officially, no one beside the parent could find out about them. Féileacáin are requesting that the 1994 Act be amended to allow families to opt out and to allow their babies on the public record. Also, they're rightly suggesting that any records for the period prior to any legislative change would remain private unless requested by bereaved parents. This is an issue that families feel very strongly about. Minister, I'm sure you've seen the very personal stories that some of the bereaved parents have shared as part of the campaign. One of these stories, Liliana's story, describes the shock and pain of a stillbirth. Her parent details how it is not a tragic event, and I quote, but a lifelong process where you learn to live in a world that has shifted and you no longer know your place in it. They go on to explain the impact of the mandatory privacy around the Stillbirth Registry. Again, I quote her parent, Liliana's siblings, nieces and nephews have no right to know about her. Future generations will not be able to include her in our family trees, despite the fact that she has had such a profound impact on her family. I felt it was an insult to her to hide her away like that. There they sum up the issue. They illustrate the additional pain that the current system forces on grieving families. The 1994 Act was passed in the best interests of parents and families and in response to the information available at the time. We now understand things differently, Minister. Will you look into what can be done to amend the law to help families suffering pregnancy and infant loss?
Thank you, Deputy Minister.
Thank you, Laska and Corla. And I would like to join with Deputy Cairns and indeed other deputies in reflecting on the enormous losses of parents as part of this month's marking of pregnancy and infant loss. I don't think anyone in this House will disagree when I say that a stillbirth must be one of the most traumatic events that parents can experience. My own experience of engaging with parents is that the loss can be overwhelming, long-lasting, and importantly, very difficult to reconcile. When legislation to establish a Stillbirth Register was enacted over 25 years ago, this state was 30 years behind Northern Ireland and 40 years behind England and Wales in giving formal state recognition to a stillborn child. The Minister of the date, the late Mervyn Taylor, when introducing the bill in 1994, outlined his approach to the long-awaited legislation. He explained that his approach was determined by two considerations. The first was to recognise the therapeutic effect that registration might deliver for grieving parents. The second was to create a permanent record akin to the register of births within the civil registration system. Acknowledging the points that the Deputy has made in terms of how our understanding has come on a long way since then, these two considerations do remain valid today, as when the legislation was first enacted. The recently published 8th report of the National Child Audit on Perinatal Mortality in Ireland, conducted by the National Perinatal Epidemiology Centre in Cork, provides essential insights into the incidence of stillbirths and perinatal deaths. The Centre has the aim of identifying quality improvement initiatives and proposing recommendations for the improvement of care for mothers and babies in Ireland. All 19 Irish maternity units reported anonymised data to the Centre. The report details that some 325 deaths occurred in 61,298 births occurring during 2018. Stillbirths and early neonatal deaths occurred for 217 and 108 of the 325 deaths, respectively. For 2019, 360 deaths arising from 59,574 births were reported, and stillbirths and early neonatal deaths accounted for 242 and 118 of the 360 deaths, respectively. The General Registration Office is notified of all births that occur. It reports similar data stating that between 300 and 350 families are affected each year by loss due to stillbirth and early neonatal deaths. The GRO also observed that due to the voluntary nature of the stillbirth registration process, around half of parents select to register the event, perhaps in part reflecting the huge loss suffered by parents and their wider family. I would encourage parents to register. The Stillbirth Register can provide a tangible record and acknowledgement of stillborn children. While it can serve as a focus for the memories of bereaved parents, it also has the strength of providing familial linkages for future generations, but only if the records can be accessed. In her contribution to tonight's debate, Deputy Cairns has conveyed the proposals advanced by advocacy groups that seek legislative change to open the Stillbirth Register to public access in a way that is similar to birth, marriage and death registers. The Civil Registration Act provides that no person other than the Registrar General or a member of the staff of the GRO is authorised to search the register of stillbirths. The GRO provides whatever assistance it can to enable searches. There are restrictions on providing copies of the information held in the form of a certificate to anyone other than a parent. The Minister for Social Protection, my colleague Heather Humphreys, TD, indicated that she is willing to reassess these restrictions as they are set out in the Act. She has indicated that it may be that we do not go as far as providing full public access as in the case of the birth register, given the sensitivities involved, but that other less limiting forms of access could be considered. We should recognise too that the parents who for their own reasons choose not to register. And I think it's timely given the month that we are in, and I welcome the Minister's commitment to open a dialogue on how we can do this better. The Minister has asked the GRO to examine the policy and legislative implications involved in making the Stillbirth Register more open, and if it should in fact be fully open as with other public registers as proposed.
Thank you, Minister. Deputy Cairns.
Minister, thank you for your response. For the families involved in the campaign, public registration is a means of recognising their child. In legislative terms, it's a relatively minor change, but one that can have a big impact. And you said the Minister has indicated that she will look at it, but maybe not to the extent that we're talking about. But I suppose it's important to highlight that Féileacáin want to give parents the option on how they register the child rather than a blanket approach, so maybe that's something she can look at. But I implore you to begin the process to change the law and to give families a system that better reflects their needs, and it'd be great to liaise with those voluntary-led organisations on the move to a change. Minister, given your portfolio, there's also a related matter which needs some consideration. Under social protection regulations, mothers of stillborn infants, that is infants born after 24 weeks of pregnancy, are entitled to maternity leave and to maternity benefit. However, those who suffer miscarriages or loss under 24 weeks are not entitled to anything. So this means that two families, often in very similar circumstances, are treated very differently depending on whether the tragedy falls a few days before or after the 24-week mark. And whilst I understand that regulations sometimes require frameworks such as a sharp divide, it just doesn't reflect the reality of pregnancy and infant loss. And I urge you to look at how this matter can be reformed. Also, just briefly, the UK Department of Health has recently committed to a strategy of halving the rate of stillbirths and neonatal deaths in England by 2025. So I wonder if you can ask your counterparts in the Department of Health to follow that example or look into what exactly has been done there in order to achieve that, to reduce pregnancy and infant loss. And finally, it's just important to recognise the work of groups such as Féileacáin or the Miscarriage Association of Ireland, who do incredible work supporting families, and the Pregnancy Loss Research Group and the National Perinatal Epidemiology Centre in UCC, who provide vital research in this area. Thank you.
Margaret Minister to conclude.
I do welcome tonight's short debate on this very important matter. It has afforded the House the opportunity to mark Pregnancy and Infant Loss Month. We know that 300 to 350 families are affected by stillbirths annually. Minister Humphreys is also conscious of those parents that registered stillbirths, knowing those records would not be open to public access. So some formulation should be found to accommodate their needs and wishes. In my earlier comments, I mentioned that the Minister of the day set two aims for the legislation when it was first introduced in 1994. The first was to recognise the therapeutic effect that registration might deliver for grieving parents, and the second was to create a permanent record akin to the Register of Births within the civil registration system. The challenge is to see these two aims are being addressed with the current manner in which registrations are completed and records accessed. As the legislation currently stands, access is very restrictive and is somewhat out of line with access allowed for other forms of registration where sensitivities are also engaged. The Minister is committed to engaging with parents and interested parties to see if a better formulation can be found to address their concerns, whilst also aligning the operation of the Stillbirth Register with other registers maintained by the GRO. And I will take the point you made around access to maternity leave and maternity benefit back to the Minister as well. And I wish to thank you for the opportunity to address this topic this evening. Thank you.